No tanto que yo. No, pero sí. Sí. Otra cosa. Ay, abajo. Y sí,
Ujú. Mm. No,
sí.
no,
Okay, the person that's on Zoom, iPhone 3, would you please state your full name?
Juan O. Guerrero.
Guerrero?
Yes,
Okay.
sir.
Now, Mr. Guerrero, the case is set for an arraignment today. You are required to be here in person,
Yes, sir.
okay?
Okay.
So, are are you in Beaumont,
No, I live in Pasadena,
Mr.
Texas.
Guerrero?
Yes, sir. I live in
Okay,
Pasadena.
Pasadena. Okay, you were supposed to be here in person. Now, what the court is going to conduct the arraignment, and the reason why you have to be here in person is because there's some paperwork the court will go over, and there's paperwork that you have to read and sign.
Okay.
And
All right.
so you're not here to do that, but I'm gonna go through the arraignment. So we're gonna, once I finish with the arraignment, we're gonna reset your case on another day for you to appear in person. Do you understand?
Yes, sir.
Okay. Please put your mic on mute. Thank you. Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence L. Holmes. I'm the presiding judge here in County Court at Law Number 2. You have been asked to come to court today for what we call arraignment. And what the arraignment is, it's an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. Now, the case that you have in this court is a criminal case. In this court, we handle criminal cases, and the type of criminal cases that we handle are misdemeanor cases. Now, criminal cases are divided into felonies and misdemeanors. Your felony cases are your most serious type of offenses. They are normally, but however, your misdemeanor cases are normally referred to as your petty offense. Does not mean that they're not serious. It just means that they're not as serious as a felony case. And when I use the term serious, what I'm talking about the facts of the case and the possible punishment that a person can receive if they are convicted of the offense. Now, felony cases are divided into 5 categories, and we'll start at the top and work our way on down to the bottom. You have the capital murder, first-degree felony, second-degree felony, third-degree felony, and a state jail felony. Now, if a person is convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail and a fine that does not exceed $10,000. If a person is convicted of a third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary, and a fine that does not exceed $10,000. Person is convicted of a second-degree felony. The range of punishment is minimum 2 years to a maximum of 20 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life in the state penitentiary, and a fine that does not exceed $10,000. Now, if a person is convicted of the highest felony, which is the capital murder, the range of punishment is minimum life in the state penitentiary without the possibility of parole or death by lethal injection. Now, as I mentioned earlier, your case is a misdemeanor case, so you don't have to worry about the felony punishment. Now, misdemeanors are divided into 3 categories, and we'll start at the top and work our way on down to the bottom. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. If a person is convicted of a Class C misdemeanor, the range of punishment is a fine only. That simply means you cannot be given jail time. You only can be given a fine for the offense, and the fine is usually anywhere from $0 to $500. That's normally the punishment range. Now, however, if a person fails to pay the fine, or if the fine was converted to community service and they fail to perform community service, then the court can issue what is called a capias pro fine. That is a warrant for your arrest to either pay the fine or sit out the fine in jail. The next highest misdemeanor is a Class B misdemeanor, and the range of punishment for a Class B misdemeanor is minimum 0 days to maximum 180 days, which is 6 months in the county jail, or a fine from $0 to $2,000, or you could be given both such fine and confinement. The highest misdemeanor is a Class A misdemeanor. The range of punishment for a Class A misdemeanor is minimum 0 days to a maximum of 365 days, or a fine from $0 to $4,000, or you could be given both such fine and confinement. Now, you may be eligible for one of two types of probation. You either have adjudicated probation, which we call regular probation, or unadjudicated probation, which we call deferred probation. And the difference between the two is as follows. With the regular probation, you have a conviction on your record. However, if you successfully complete the probationary period, there's something that is called judicial clemency, whereby the court, that is the judge, can set aside your conviction and you won't have a conviction on your record. Now, in order for that to happen, you have to first complete the probation. There cannot be any more time left on the probation, and you have to be successfully discharged from the probation. If all of those three things happen, then the court has the discretion to grant judicial clemency, whereby this will not appear as a conviction on your record. However, if you get a subsequent offense, a subsequent conviction, that is, if you get another conviction later on, then the conviction that you received judicial clemency on can be revived, resurrected, and brought back up and used against you. And if you try to get a license with CPS, or they can either deny giving you a license, or they can suspend or revoke a license that you may have with CPS. Now, the other type of probation is called unadjudicated probation. We commonly refer to it as deferred adjudicated probation. Now, with the deferred or unadjudicated probation, it does not result in a conviction on your record. However, if you fail to complete the deferred probation, then the court can revoke your probation. And if the court revokes your probation, the court can either give you jail time or put you on regular probation, which does result in a conviction on your record. Now, if you successfully complete the probationary period for unadjudicated probation, this will not result in a conviction on your record. The case will be dismissed, and you may qualify for what we call a non-disclosure. And what a non-disclosure is, it simply means that your record will be sealed to the general public. Now, when I say your record will be sealed from the general public, that means that the general public cannot have access to your criminal record. However, the government can, for example, the federal government, the state government, city, or local government agencies, they can have access to your record. Now, everyone that's here today, now you have that paperwork that is on the clipboard. I'm going to go over that paperwork with you. There should be a document on there that is titled Judge's Explanation of Rights to Defendants Without an Attorney. I'm going to go over that document first. And that document states that as a defendant in a criminal case, you have three options regarding your right to have an attorney. Number one, you may hire an attorney. Number two, if you do not have enough money to hire an attorney and you would like to have an attorney appointed to represent you, you may request that an attorney be appointed to represent you. Or number three, you may represent yourself. Now, in order to represent yourself, you have to waive or give up your right to have an attorney. Now, as a defendant in a criminal case, if you would like to hire your own attorney, your case will be reset. Reset means that you'll be given another court date from the day to give you time to hire your attorney. If you want an attorney, but you do not have enough money to hire an attorney, then you will have to first fill out a financial questionnaire. A financial questionnaire is a document on the clipboard that is titled Jefferson County Affidavit of Indigence. You would have to fill out the first page of that document, and it asks you at the bottom of that document, it asks for your financial information, your income, and your expenses. And then on the second page, you'd have to fill out the second half of the second page. And at the bottom of that page, where it says whether or not the defendant currently meets the eligibility requirements, that's for the court. You won't have to fill that portion out. And you will not have to fill out the third page. That is also for the court. Now, if you want to represent yourself, that is, you want to waive your right to an attorney and represent yourself, you will have an opportunity to speak to one of the assistant district attorneys who is currently present in court. We call them prosecutors. You'll have an opportunity to talk to one of the two prosecutors that's sitting at the table in front of the board. Now, before you can talk to them, you will have to first read and sign a waiver of counsel, and it's titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. That's another document on the clipboard. And I will go over that document with you in a few minutes. But first, we're going back to the first document that talks about, that is titled Judge's Explanation of Rights to Defendants Without Attorney. It states that you should be aware that there are dangers and disadvantages to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, if you choose to waive your right to an attorney and represent yourself, you may change your mind at any time and request that an attorney be appointed to represent you. Now, at the bottom of that document, where it states defendant's choice, it says that in bold letters, defendant's choice, mark initials next to only one choice. If your choice is to hire your own attorney, then you will place your initials on the first line to the left. If you have already hired an attorney to represent you in your case, then you will place your initials on the second line to the left and the name of the attorney on the line to the right. If you would like to apply for a court-appointed attorney, then you will place your initials on the third line to the left. If you've already been appointed a court-appointed attorney to represent you in your case, then you will place your initials on the fourth line to the left and the name of the attorney on the line to the right. If you want to waive your right to an attorney, that is, if you want to give up your right to have an attorney to represent you and you would like to represent yourself, then you will place your initials on the fifth line to the left. Now, once you have finished initialing one of the 5 lines, then you will sign your name on the line that is titled Defendant, and you will date it today's date, June 25th, 2024. Now, for those of you who will be waiving your right to an attorney, that is, you want to waive your right to an attorney, you want to represent yourself, you would have to read and sign the next document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. And this is only for people who will be waiving their right to an attorney and representing themselves. Everyone else, you don't have to read and sign this document. But this document reads as follows. As a defendant in a criminal case, said, I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily meaning that you're doing it of your own free will. No one is forcing you to do this. And intelligently made. Intelligently meaning that you know what you are doing. So it states, my waiver is voluntarily and intelligently made. Furthermore, I have been advised this 25th day of June 2024 by the County Court at Law Number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I'm unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed to me free of charge if I am not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. If that is your choice, then you will sign your name on the line that is titled defendant, and you will date it today's date, June 25th of 2024. Now, as a defendant in the criminal case, you also have a right to have a trial by jury. That area over there where those 12 chairs are, we call that the jury box. 6 citizens from Jefferson County will be selected to sit as jurors in your case. They will listen to all of the evidence and the arguments, and then they will deliberate. After they deliberate, they will decide to either find you not guilty or guilty of your charges. Now, you also have a right to waive, which means to give up your right to have a trial by jury. Now, by waiving or giving up your right to have a trial by jury, your case will come before the judge or the court in one of 3 ways. One way it can come before the judge is by way of a trial. We call that a bench trial. It's a trial by judge only. The judge will be the judge and the jury in the case. Now, the judge will listen to all of the evidence, the arguments, and then the judge will decide whether to find you not guilty or guilty of your charge. Another way that your case can come before the judge is by way of an unagreed plea bargain. Now, plea bargains are divided into 2 categories. And first of all, a plea bargain is an agreement that you work out with the state or with the district attorney's office to settle your case. We call that a plea bargain. Now, there are 2 types of plea bargain. One type of plea bargain is called an agreed plea bargain, which means that you and the state have reached an agreement to settle your case. The other type of plea bargain is called an unagreed plea bargain agreement, which means you and the state have talked, you've negotiated, however, you have not reached an agreement to settle your case. So we call that an unagreed plea bargain because you want to settle your case, but you haven't agreed to the punishment, or you have been unable to agree with the state regarding the punishment in your case. And so you want the judge or the court to decide what your punishment will be in your case. And the judge, the punishment will be within the punishment range that you have by statute. And I mentioned it to you earlier. If it's a Class B misdemeanor, the range of punishment is 0 days to 180 days, a fine from $0 to $2,000, or you could be given both such fine and confinement. If it's Class B, the range of punishment, Class A, the range of punishment is $0 to $4,000, 0 days to 365 days, which is a year in the county jail, or you could be given both such fine and confinement. If it's a Class C misdemeanor, the range of punishment is $0 to $500. And so the judge will decide what the punishment rank would be in your case. That is, if you have an unagreed plea bargain. Now, the other way that your case can come before the judge is by way of an agreed plea bargain. What an agreed plea bargain is, you and the state have reached an agreement. And so then the case comes before the judge. The judge can do one of 2 things. The judge can accept the plea bargain agreement or reject the plea bargain agreement. Now, if the judge rejects the plea bargain agreement, you have a right to take your plea back. And now I'm using the word plea. And what I mean by that is you have a right to enter one of 3 types of pleas. You can enter a plea of guilty, which means that you're telling the court that you committed the offense that you've been charged with. You can enter a plea of not guilty, which means that you're telling the court that you did not commit the offense that you've been charged with, or you can enter a plea of no contest, which means that you're telling the court that you will not be contesting or you will not be fighting the charges. Okay. And so if you enter a plea of guilty or no contest and you have a plea bargain agreement, it comes before the judge. If the judge rejects the agreement, you have a right to take your plea back. Now, if the judge accepts the plea bargain agreement, and if you decide within 30 days after pleading guilty or no contest that you think you've been wrongfully convicted or whether or not the court committed an error by convicting you, then you would like to appeal your case, you would have to get permission from the judge to appeal your case. And when I use the term appeal, what I mean is this. Your case will go to a higher court than this court for them to review the case to see whether or not you have been wrongfully convicted or whether or not this court committed an error by convicting you. That's what we call an appeal. Now, the judge has to give you permission to appeal if he follows the plea bargain agreement. If the judge gives you permission, then your case will leave this court and go right upstairs to the Ninth Court of Appeals. And the Ninth Court of Appeals is right above us on the 3rd floor. They can do one or two things. They can grant or deny your appeal. If they grant your appeal, they can just simply find you not guilty, or they can send the case back down to this court and order this court to give you a whole new trial. If they deny your appeal, then you can appeal your case to a higher court than the Ninth Court of Appeals. You can appeal your court case to the highest criminal court in the state of Texas, which is the Texas Court of Criminal Appeals located in Austin, Texas. You would have to file what is called a pro se petition for discretionary review. Now, the Texas Court of Criminal Appeals in Austin, Texas could do one or two things. They can grant or deny your pro se petition. Now, a pro se petition, what that means is that pro se means you're representing yourself. We say that's pro se. You don't have a lawyer representing. And your petition is you're petitioning the Texas Court of Criminal Appeals to review your case, to see whether or not your appeal should have been granted, or whether or not this court committed an error by convicting you, or whether or not you were wrongfully convicted. They can do one or two things. They can grant or deny your pro se petition. Now, if they grant your pro se petition, they can simply find you not guilty, or they can send the case back to the Ninth Court of Appeals, or they can send it back to this court and order this court to give you a whole new trial. If they deny your pro se petition, then at that point, your conviction will stand. Now, you also have a right to have witnesses to come to court. Witnesses sit in that chair over there. We call that the witness stand. And what witnesses do, they can testify in your case. They can testify for you or against you. Now, if you're representing yourself, you can ask them questions, or if you have an attorney representing you, your attorney can ask them questions. We call that either direct examination or cross-examination. You also have a right to waive or give up your right to have witnesses to come to court, which means that you will not be calling witnesses. It does not mean that the state will not be calling witnesses, because they will be calling witnesses in the case that they have against you. Now, you also have a right, we call it a right to have discovery. And what discovery is, you have a right to see the evidence that the state has and will be using against you in your case. We call that discovery. That is, you have a right to see witness statements, your statements, witness statements, reports, police reports, lab reports. You have a right to see recordings, audio recordings, video recordings. You have a right to have access to any instruments that they may have and will be using in your case. Photos, you have a right to see photos if they have photos. And so you have a right to see the evidence or have access to the evidence. We call that discovery. Now, you also have a right to waive or give up your right to have discovery. If you waive and are giving up your right to have discovery, that means that you do not want access to the evidence that the state will be using against you. Now, everyone that's here today for a case You have been arrested, you've bonded out of jail, and you're either out of jail on a cash bond, which means you paid the full amount of the bond to get out of jail. You're out of jail on a surety bond, which means that you paid a bondsman a percentage of the bond to get out of jail, or you're out of jail on what we call a PR bond or a personal recognizance bond, which means that you did not have to pay anything to get out of jail. You was released from jail under your own personal recognizance with a promise to appear here today. Now, every day that you spent in jail can be used as credit toward your punishment. So, for example, let's say you spent 5 days in jail and you bonded out, and you and the state have talked, and you have reached a plea bargaining agreement, and the plea bargaining agreement is that you will serve 5 days in jail. What that means is you will not have to serve any more time in jail because you've already served 5 days in jail. Therefore, you'll be given credit for the time that you've already served. Now, if the state is offering 7 days in jail and you serve 5 days in jail, that means you will not be required to serve 7 days in jail. You will only have to serve 2 days in jail because you've already served 5. We'll take 5 from 7, and that leaves 2. Now, every day that you spent in jail can also be used as credit toward your fine and court costs. So, for example, let's say with the fine and court costs, you receive $100 for each day that you spent in jail as credit toward your fine and court costs. So if you spent 5 days in jail, that's $500 credit that can go toward your fine and court costs. So if the state is offering you fine and court costs of $500, that means you won't have to pay. Why? Because the 5 days that you spent in jail is $500, and so therefore it will be taxed against you and retired, which means that you won't have to pay it. Now, if they're offering fine and court costs of $700 and you spend 5 days in jail, that means you'd have to pay $200 because you already have $500 credit, and 500 from the 700 leave 200. So you have $200 that you would have to pay on the day that you dispose of your case. Now, if you can't pay the fine on the day, the fine and court costs on the day that you dispose of your case, then there's no problem because the court can convert your fine and court costs you can be placed on a payment plan. That is, you can pay off so much money until it's paid off. Now, if you're unable to pay off the payment plan, then we can convert the fine and court costs to community service, which means that you will work at a nonprofit organization in our Golden Triangle area, and for every 1 hour that you work, you will receive $12.50 that will be credited toward your fine and court costs. So, for example, if you had to pay $200, well, if you work one 8-hour day, that's $100. You work 2 8-hour days, that's $200. So if you work 2 8-hour days at a nonprofit organization, you would have paid off the $200 that you were required to pay. Now, Jefferson County has a program that is called pretrial diversion. When I say Jefferson County, I'm talking about the district attorney's office. Jefferson County District Attorney's Office has a program that is called pretrial diversion. It is a program where they will dismiss your case and you can get it wiped off your record. How does it work? Well, in order to qualify for the program, this has to be your first time getting in trouble. Cannot be for an offense involving unlawfully carrying a weapon or resisting arrest. And you have to have an attorney to assist you at getting into the program. Now, once you get into the program, case will be dismissed. Once you complete the program, you can get it erased, deleted, or wiped off from your record. We call that expunged. It won't be on your criminal record. Now, if you are a veteran of any one of the military branches, Jefferson County District Attorney's Office also has another program, which is part of the pretrial diversion program, that is called Veterans Court. With the Veterans Court program, which is for veterans only, you get into the program, complete the program, they will dismiss the case, and you can get a non-disclosure. and I mentioned earlier, non-disclosure whereby your record is sealed to the general public. Only thing you have to do to get in that program is have, if you served in any one of the branches of the military, you qualify to get into the program. Simple as that. Now, this court, Jefferson County Court at Law Number 2, has a program that is called the CSI program. CSI stands for Community Safety Initiative. And with the Community Safety Initiative, that is a program that I started in March of 2017, within the first 100 days of taking office. I took office in December of 2016, started the program March of 2017. With that program, the program is designed to address the issue of what we call recidivism. Recidivism means people who commit crimes over and over. How do we stop that? Well, we stop it with the Community Safety Initiative. And with the Community Safety Initiative, we have partnerships with agencies within our local community. For example, we have a partnership with Spindletop Center. Spindletop is our local mental health center here in our Southeast Texas region. And with Spindletop have the expertise to conduct interviews. It could be private interviews. All of the interviews are private, either here in the jury room, or it could be at their facility, or it could be by telephone, whichever is convenient for you. They can develop and do an assessment. And the next thing they can do, they can develop a treatment plan for either outpatient or inpatient treatment, depending on your mental health needs. Now, you do not have to be insane or incompetent to participate in the program. You could merely suffer from anxiety or depression or any other host of mental illnesses. As I mentioned earlier, Spindletop has the expertise to address your mental health needs. Spindletop also has a program that is called ATAR. ATAR is an acronym, ATAR, that stands for Addiction, Treatment, and Recovery. With that program, our local mental health council has a program that is called OSAR. OSAR stands for Outreach, Screening, Assessment, and Referral. Both programs are alcohol and drug recovery programs. They have the ability to do a screening, an assessment, and they can develop a treatment plan if it's either outpatient or inpatient treatment. If you are unemployed or if you're looking for a better job, well, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. And Lamar University has a program that is called CICE. CICE is an acronym that stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, or the chemicals and the chemical industry. Once you are trained in one of those three areas that you select, then they will assist you at getting a job in the area that you're trained in. Now, if you have not graduated from high school, or if you would like to get a GED, graduate equivalency diploma, well, CICE has a GED program. Now, all of these programs that I've just mentioned to you are free. That means it doesn't cost you anything but time. And I like to say in this court, we don't just give time, we take our time. That is, we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And if we produce productive people, then we can make Jefferson County a safer place for all of us to work, go to school, raise our children, go to church, and raise our families. I like to say in this court, We don't have court as usual, we have unusual court, and it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. And if we make a difference in their life, then we will make a difference in their home. And if we make a difference in their home, we will make a difference in the community, because what comes out of the home goes into the community. Now, if you're interested in any one of these programs, just let us know. And the other thing about this program, all of these programs that I mentioned are not only free, but they can be used as community service. Now, for example, let's say you were ordered to pay a fine and court costs, but you couldn't pay your fine and court costs because you don't have the income. And the court community converted your fine and court costs to community service. And so for every 1 hour that you're being trained, and let's say for a job, or for every 1 hour that you're getting drug or alcohol treatment to address your alcohol or drug treatment or your drug addictions, or for every hour that you're in services at Spindletop, or for every hour that you're in class getting a GED, $12.50 will be going toward payment of your fine. And 1 hour will be going toward the program. So you're not just killing 2 birds with one stone, you're killing 3 birds with one stone. You're in the program, you're getting community service, and you're paying your fine and court costs, all by doing one thing, okay? And if you're interested, we have some brochures that we can give to you so that you can get started in any one of the programs that I just mentioned, or any one of the programs that I also mentioned that the district attorney's office have to offer. Now, at this time, we have some folks from the Spindletop Center that I mentioned earlier. They're going to come to you right now and tell you a little bit more about the program that Spindletop Center has to offer. At this time, we have Deputy Hinton and Chris. Y'all please come forward.
Thank you, Your Honor.
You're welcome.
Morning. My name is Steve Hinton. I'm a mental health deputy licensed by the state commission here with the sheriff's department. This is my coworker, Chris. Now, Chris is a qualified mental health professional. The reason we are both here this morning in this courtroom is because the judge cares about every single person that comes before the bench. But the judge has found that statistics proves those who have legal issues commonly have mental health needs, such as shooting disorders, or sometimes just a lack of community resources to help you in a particular situation.
So when it reads like mental health needs, it seems like anxiety, depression. Obviously, there's a host of other issues that can and do happen, and that we can't help with, but those are the ones that we see most of the time in the court. And outside of that, those are the ones that all of us will deal with at some point in our lives. There's a lot of really great community resources out there that are well funded, not well. Sometimes even just finding the name for one can be a bit like something good. And that's the word.
So maybe this is your first time to be here, maybe it's your 10th time to be in court. There's still hope. In fact, what we're offering you today has the ability to change your life. We're going to need something from you. And Chris will explain exactly what we will need very quickly.
So when you guys came in, you were all handed one of these forms, right? This is built like a baseline of the consent form. The reason it's built this way is so that you know the information you put on the sheet is protected under state law, the same as your medical information. The only thing you consent to on this is me contacting you once and then you reach you. The only person who will reach out will be me. The number that you receive from that goes directly to me if there's anything else you need. The goal in this is not to interrupt your lives, but to rather kind of match your schedule and match what you need. If you want to keep talking with me, if you want to get more information, if you have something you need, if you reach out and hear from me, it's not gonna, it's still within the budget. What matters is that a lot of times like resource that most of you think is just support, or someone who can point out where things are just out in the field. This is not limited just to Jefferson County. We work with anybody. This is also not going to cost anything. We still understand that one of the biggest causes is stress is financial. So we are not trying to add on anything on that regard. Anything we set you up with or direct you to, if I can decide to please scale or state funded. We're state funded. Talking to us doesn't cost anything. We just exist as a giant loophole. We know that all of you work hard for yourself to make sure that today. I know it's not a moment that anybody wants to find themselves in, or wants to find themselves in. And this is not a moment where I want to have a lot of information for how to go. And that one is only stressful. We are just here to make it as easy as possible for you. You all should, you all work hard for yourself, like I said. We want to match them. I know that it's hard to feel if this is productive, but we want to be able to provide some kind of help outside of your general life as well as to make it scale in your moment.
I also have a flyer here that I want to get in everyone's hands before you leave here today. On the back, it tells you some of the advantages of actually participating, but on the front, it also has a 1-800 number. Should you ever find yourself in an unsafe place, you can call that number to help immediately.
Now, first off, in a big crisis number, right? If you fill us out, you have my direct number as well, and we can also get you off the if you need it. But that number is 24/7. You call it on Christmas Day at 6 a.m. and we'll pick up. If there's something going on or something you need to talk to about, they will be there. That is also active almost statewide. I say almost because we know there's plenty of places in Texas where no cell phone works, no matter what you do. So, but outside of that, it doesn't matter where you are, you can call. It also doesn't matter, again, if you're from Jefferson County, we are not limited by locality. If you guys, we had somebody, talk with us from California, report to somebody who's from Oklahoma, it doesn't matter where you're from. Or rather, most people who live in Fort Jefferson County from nowhere near closest area. So if there's something you need to help find it, or you need a sympathetic ear, or just someone to talk to, we're here.
Just shortly, the court is going to go into recess, and when he goes into recess, we'll be able to come out there, we'll visit with you, we'll pick up those documents from you, we'll answer any questions you have, we'll also provide this at that time.
With any point, there's any emotions that come, if there's anything. And so this is not, I know you all showed up and there's 20 people that they called outside that probably didn't come to the doors. You got here, but this is not a place or a time or anything that lends itself to relaxing, right? There's a lot of stress, there's a lot of anxiety involved. If at any point you want to start feeling symptoms of panic, or you just need to take a moment to breathe, let us know. We'll be watching. That way we can take a step out or just come sit with you or wherever you may need the moment to help manage this effectively.
Thank you. Listening.
Right.
Thank you, Your Honor.
Thank you, Deputy Henry. Chris. Now, ladies and gentlemen, the paperwork that you have on the clipboards, we're going to pick that paperwork up from you. And we're going to, once we finish going through the paperwork, we're going to ask that you will come up before the bench one at a time. Now, it's going to take us some time to pick up the paperwork and evaluate it, and then ask you to come up before the bench. And so if you need to use the restrooms, there are 2 restrooms right outside the courtroom. The men's restroom is in front of County Court at Law number 3. And the female restroom is on the opposite side of the hall in front of 172nd District Court. Please do not leave the courthouse. If you leave the courthouse and if your name is called and you're not here in court to answer, then your bond can be forfeited. And if your bond is forfeited, a warrant will be issued for your arrest. Now, if you need any assistance with filling the paperwork out, we have our court personnel who's here, who is ready and able to assist you at filling out the paperwork. And before we go into recess, if you need any assistance with filling the paperwork, I'll just simply raise your right hand, just simply raise your hand, and then we'll have someone to come out to you, help you with filling the paperwork, or I can ask you to come up to the bench so I can go over the paperwork to make sure that it is filled out properly. So at this time, the court will be in recess, and I think the folks from Spindletop is also, they're going to come out and go over some of the paperwork that you have from Spindletop. So at this time, we'll be in recess.
That was one more. And it's out to everybody. It doesn't matter if you're here yourself or if you're here to support. And it doesn't matter if you have information for you or someone you care about outside of it. Think that's a loophole. So we just everybody comes in here.
Okay. We'll be in recess. Jefferson County Court at Law number 2 is back in session. Court is in session with its arraignment docket. First case is clause number 236 CCR 1484 case is filed in the state of Texas versus Juan Omar Guerrero. Mr. Guerrero is appearing via Zoom. Mr. Guerrero, you can take your mic off of mute.
Yes, sir.
Okay, now, Mr. Guerrero, your case has been reset to next week,
Okay.
and that's July 2nd.
Yeah,
You need to,
second.
you need to be here in person.
Okay. Yes, sir.
So your reset will be sent to you and your bondsman. You're free to go. And you have a blessed day. That's July 2nd at 9 a.m.
At 9 a.m. Okay.
All right. You're free to go. You have a blessed day.
You too. Thank you.
Thank you. You're welcome.
Dos.
Mhm.
A los
Next case is called number 24CCCR 0912. Case is style the state of Texas versus Joshua DeAndre Cormier. Please come forward. Come forward, stand in front of the bench. Okay, Mr. Cormier, your full name is Joshua DeAndre Cormier?
Yes, sir.
Mr. Cormier, would you please raise your right hand? Swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir. No, no, true.
Okay, you may put your hand down. Mr. Cormier, you have gum in your mouth?
Yes, sir.
You need it. There's a trash can to your right. You can take the gum out your mouth and throw it in the trash can. It's right to you, right in front of you. Okay. Now, Mr. Cormier, how are you doing?
Doing good.
Well, that's good. Mr. Cormier, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir. Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
At the top of this document, there's a set of initials, and the initials are on a line that states, I want to reset to hire my own attorney.
Yes, sir.
Now, before you sign and initial this document, Did you read the document?
Yes, sir. I had some help to go over it.
Okay, you had some help and you understood everything in this document?
Yes, sir.
And is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Cormier, your case is going to be reset to give you opportunity to hire your attorney. Our court coordinator is going to reset your case. Please have a seat in that first chair on the wall and she'll call you up to her window.
Aye.
And you have a blessed day. Next case is cause number M333520. Case is style state of Texas versus Alfred Theron Pollard. Mr. Pollard,
Sir.
your full name is Alfred Theron Pollard.
Yes, sir.
Mr. Pollard, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
Mr. Pollard, you may put your hand down. How are you doing, Mr. Pollard?
Yeah.
That's good. Can't be better than being blessed. Now, Mr. Pollard, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? And is this your signature on the line that's titled defendant?
Yes, sir.
And are these your initials on the line that states you want to waive your right to attorney and represent yourself?
Yes, sir.
I also have another document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial.
Yes, sir.
You recognize this document? And is this your signature on the line that's titled defendant?
Yes, sir.
Now, Mr. Pollard, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Pollard, I read your answers. You can go back and have a seat where you're sitting, and someone from the district attorney's office is going to come out and talk to you about your case. All right. Next case is cause number 24CCCR/0130. Case is style of state of Texas versus William Chase Page. Mr. Page, your full name is William Chase Page. Ms. Page, would you please raise your right hand? Mr. Page, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God? Mr. Page, you may put your hand down. How are you doing, Mr. Page? That's good. Now, Mr. Page, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? Is this your signature on the line that's titled defendant?
Yes, sir.
Or are these your initials on the line that state you'd like to apply for court appointed attorneys?
Yes, sir.
I have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes.
On page 2 of this same document, there is a signature above the line that is titled defendant signature. Is this your signature?
Yes, sir.
Mr. Page, before you sign and initial these documents, did your attorney go over these did you go over these documents?
Yes, sir.
And did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Page, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. The attorney that will be appointed to represent you in this case is Attorney Marva Provo. Attorney Provo will be given information to contact you, and you will be given information to contact her. Our court coordinator will give you that information. Once you get the information from the court coordinator, you'll be free to go. And you have a blessed day. Please have a seat in that first chair on the wall. Chelsea Renee Newton. Miss Newton, your full name is Chelsea Renee Newton. Ms. Newton, would you please raise your right hand? Ms. Newton, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Ms. Newton, you may put your hand down. How are you doing, Ms. Newton?
Fine.
That's good. Ms. Newton, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled defendant?
Yes, sir.
Or are these your initials on the line state you'd like to apply for court-appointed attorney?
Yes, sir.
Next document is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of the same document, there's a signature above the line that is titled defendant's signature. Is this your signature?
Yes, sir.
Ms. Newton, before you sign and initial all of these documents that I just showed you, did you read the documents?
Yes, sir.
Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Ms. Newton, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that would be appointed to represent you in this case is Attorney Joel Vasquez. Attorney Vasquez will be given information to contact you. You will be given information to contact him. The court coordinator will give you that information. Once you get that information, you'll be free to go. You have a blessed day. Now, before she gives you that information, I need to give you some bond conditions. The bailiff is going to give you some bond conditions that I'm going to go over with you. Ms. Newton, you've just been handed a document that is titled Standard Bond Conditions in County Court at Law Number 2. Do you see that title?
Yes, sir.
Okay. I'm going to go over these bond conditions with you. Any reasons follows. Following return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Sir.
And condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that?
Yes, sir.
All right. Now, condition number 4 does not apply. However, condition number 5 does apply. And condition number 5 states, the defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn, full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes, sir.
Now, Ms. Newton, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand that?
Yes, sir.
Okay, now, Ms. Newton, please have a seat in that first chair on the wall. Okay, that's her copy. Next case is cause number 24CCCR 0616. Case is style of the state of Texas versus Joy Alexandria Hill. Ms. Hill, your full name is Joy Alexandria Hill. Ms. Hill, would you please raise your right hand? Ms. Hill, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Hill, you may put your hand down. How are you doing, Ms. Hill? That's good, Ms. Hill. I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? Is this your signature on the line that's titled Defendant? And are these your initials on the line that state you'd like to apply for court-appointed attorney? I also have a document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document? On page 2 of this same document, there's a signature above the line that is titled Defendant Signature. Is this your signature? Now, Ms. Hill, before you signed and initialed these documents, did you read the documents? Did you understand what you read? So you got help with the going over the documents? Okay, now did you understand everything in these documents? And is everything in these documents true and correct to the best of your knowledge? Okay, Ms. Hill, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney William Wilkerson. Attorney Wilkerson will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Have a seat in that chair on the wall. Next case is Zana Harden. Ms. Harden, your full name is Zana Harden.
Yes, sir.
Ms. Harden, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Ms. Harden, you may put your hand down. How are you doing, Ms. Harden?
All right.
That's good, Ms. Harden. I have before me 2 documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant? Are these your initials on the line
Yes, sir.
that state you like to apply for a court-appointed attorney?
Yes, sir.
I also have a document that is titled Jefferson County Affidavit of Indigence. You recognize this document?
Yes, sir.
On page 2 of the same document, there is a signature above the line that is titled Defendant Signature. Is this your signature?
Yes, sir.
Now, Ms. Harden, before you sign and initial these documents that I just showed you, did you read the documents? Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct
Yes,
to the
sir.
best of your knowledge?
Yes, sir.
Okay, Ms. Harden, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Charlie Rojas. Attorney Rojas will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Please have a seat on that 3rd chair on the wall.
Thank you.
You're welcome. Next case is cause number 23CCCR 2176. Case of style of State of Texas versus Karen Elizabeth LeBlanc. Ms. LeBlanc, your full name is Karen Elizabeth LeBlanc. Ms. LeBlanc, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. LeBlanc, you may put your hand down. How are you doing, Ms. LeBlanc? That's good, Ms. LeBlanc. I have before me 2 documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes.
Or are these your initials on the line that state you like to apply for court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document? On page 2 of this same document, there's a signature above the line that is titled Defendant Signature. Is this your signature? Ms. LeBlanc, before you sign and initial these documents that I just showed you, did you read the documents? Did you understand what you read? Is everything in these documents true and correct to the best of your knowledge? Ms. LeBlanc, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you in this case is Attorney Langston Adams. Attorney Adams will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information, and once she gives you that information, you'll be free to go, and you have a blessed day. Please have a seat on that 4th chair on the wall. Next two cases are cause numbers 24CCCR 0786 and cause number 24CCCR 0787. Both cases are styled the state of Texas versus Harris Leon Joseph Robichaud IV. She can move down to that first chair. Okay. Okay, Mr. Robichaud, your full name is Harris Leon Joseph Robichaud IV.
Yes, sir.
Mr. Robichaud, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Robichaud, you may put your hand down. How are you doing, Mr. Robichaud?
Fine. Even.
I'm doing fine, thanks for asking. Mr. Robichaud, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
And is this your signature online as titled defendant?
Yes, sir.
Or these your initials online that state you'd like to apply for a court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there are a set of initials on a line next to a box that's checked. Well, there's a signature above the line that is titled defendant signature. Is this your signature?
Yes, sir.
Mr. Robichaud, before you signed and initialed these documents, did you read the documents?
Yes, sir.
Sounds- You got help? And did you understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Robichaud, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you is Attorney Don Boudreaux. Attorney Boudreaux will be given information to contact you, and you will also be given information to contact him.
Yes, sir.
The court coordinator will give you that information, but before she gives you the information, I need to give you some bond conditions. The bailiff is gonna hand you a document that is titled Standard Bond Conditions in County Court at Law Number 2. Do you see that title?
Yes, sir.
I'm going to go over this document with you, and it reads as follows. Following the return of criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And condition number 3 and 4 does not apply. However, condition number 5 does apply, and condition number 5 states as follows. Defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 of the Texas Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes, sir.
Now, Mr. Robichaud, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, a warrant will be issued for your arrest. Do you understand that?
Yes, sir.
And also, Mr. Robichaud, I need to, you're interested in the CSI program, is that correct?
Yes, sir.
I'm going to give you a document with information about job training and job placement at Lamar University. And you can call the number that's on this document, and they can tell you how you can get involved and get started in that program.
Yes, sir.
All right? Just have a seat in that third chair on the wall.
Could you give another?
You need another one?
Yes.
Okay. That's for Mr. LeBlanc. I mean, Miss LeBlanc. There you go. There's a number on there you can call to call Lamar University. It's at the bottom. You get them started in that CSI program. Okay, that was Robichaud. Robichaud was down Boudreaux. Oh, they're doing that status slide. Next case is cause number 24 CCCR 0864. Case is style of state of Texas versus Marcos Cervantes. Mr. Savant, is that Cervantes? Cervantes? Mr. Cervantes, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay, you may put your hand down. Mr. Cervantes, how are you doing? I'm doing fine, thanks for asking, Mr. Cervantes. I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes.
On page 2 of the same document, well, on the next document, this document is titled Jefferson County Affidavit of Indigence. You recognize this document?
Yes, sir.
On page 2 of this document, there's a signature above the line that's titled Defendant. Is this your signature?
Yes.
Now, Mr. Cervantes, before you signed and initial these documents, you read the documents and you had help going over these documents. Is that correct? And did you understand everything in these documents?
Yes.
And is everything in these documents true and correct to the best of your knowledge?
Yes.
Okay, now, Mr. Cervantes, I read your answers. I need to go over some information with you in this case. And it's some financial information. So what we're going to do is we're gonna put the mic on mute. So we won't disclose public information. Okay, now, Mr. Cervantes, on this document that is titled, there were some adjustments that we just made, titled Jefferson County Affidavit of Indigence. Now, is everything on this document true and correct to the best of your knowledge? Okay, Mr. Cervantes, based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that would be appointed to represent you in this case, Attorney Burbank. Attorney Burbank will be given information to contact you. And you will be given information to contact him. The court coordinator will give you that information. Once she gives you that information, Mr. Cervantes, you'll be free to go. And you have a blessed day. Just have a seat in that first chair on the wall. You're welcome. Is appointed to represent the defendant. There you go. Next case, or the next two cases, are cause numbers 23CCCR 2364 and cause number 23CCCR 2366. Both cases are styled State of Texas versus Mason Andrew Novak. Mr. Novak, would you please come forward? Mr. Novak, your full name is Mason Andrew Novak. Mr. Novak, would you please raise your right hand? Mr. Novak, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Novak, you may put your hand down. How you doing, Mr. Novak? Okay, Mr. Novak, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line as titled defendant?
Yes.
Or these your initials on the line that state you would like to apply for a court-appointed attorney?
Yes, sir.
I have another document here, Mr. Novak. This document is titled, excuse me, Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
And Mr. Novak, on the second page of this document, there's a signature excuse me, above the line that is titled Defendant Signature. Is this your signature? Now, Mr. Novak, before you sign and initial these documents, Did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge? Okay, now, Mr. Novak, before we go any further, I'm going to put this mic on mute because there's some I don't want to disclose some non-public information. I need to probably ask you some follow-up questions. Hold on a minute. Okay, the court is gonna find that you're indigent based on the finding of indigency. You meet the eligibility requirements for the appointment of a court-appointed attorney. An attorney that will be appointed to represent you in your case is Attorney Giles Cole. Attorney Cole will be given information to contact you, and you will be given information to contact him. The court reporter will give you that information. Okay. And I need to go over some more information. They give you some bond conditions. Before we give you your bond conditions, I need to get some information from you, Mr. Novak. And so now, Mr. Novak, let me do this stuff.